see dead people.
To the surprise of absolutely nobody, well, maybe of your docket, the Drake versus UMG lawsuit has been dismissed by the Honorable Judge Vargas, who was presiding over the case, and we are going to be getting to the reasons why this was the case. Hi, I go by the name of Hines, your friendly neighbor Ketchup Man, and welcome to Ketchup Court, where we are on a mission to make trials and legal cases more digestible for you. Every source that I'm going to be using for this particular video is in the description below. So to go back to the Drake versus UMG debacle, I have been following this case silently and covertly since the original complaint was filed. I have read every court document. I have been in so many interactions, so I know a lot of the interactions, a lot of the takes pertaining to this lawsuit. I have been called K-bot so many times just because I have a difference of opinion. But it is important to remember that outside the hip-hop sphere, many people may not know what this particular lawsuit entails or how we even got here. Therefore, it's important to provide a brief recap of the key events leading up to this moment. This will take approximately 5, 10, 15 minutes. I have no idea. So if you do not want to know the background of the case, you do not have any care for what has happened leading up to this moment, then skip to this timestamp because that's when I begin analyzing the judge's decision. On the 15th of January 2025, Aubrey Graham, also known as Drake, had filed his official complaint against his record label UMG, and he was citing that UMG was publishing defamatory material with this song Not Like Us, and it had caused substantial harm to his reputation. The lawsuit began with a quote from Lucien Grange, who was the chief executive officer of UMG, and the quote said, "A single lie can destroy a reputation of integrity, and while it takes years to build a reputation, it can be ruined in 5 minutes." And this quote was lifted from somewhere. I haven't bothered to check out when he actually said this, but it was on March 25th, 2024. April 27th, 2024 was when Kendrick had responded to Drake's tailor-made freestyle, push-ups, you get it. If you were behind a beef, you would know what's going on here. But anyway, I am digressing. Let's move on from that. He cited 3 claims that he wants the judge to take action with, and this was defamation per se, which means that the damages does not have to be proved due to the nature of the allegations. The second claim being second-degree civil harassment, and the third claim being violation of New York business law practice, which basically alleges that UMG engaged in deceptive acts, engage in payola, which means pay-for-play practices, where corporations pay radio stations to play their artists' songs, which of course is illegal in the business world. I'm not saying that it doesn't happen. I was a DJ myself, so I know how those circles operate. I'm just saying it's illegal in the business world. Drake decided to settle with iHeartMedia on the 4th of March 2025. UMG motion to stay discovery was denied. This means that Drake has the power to compel certain materials for consideration per case law, which means that plaintiffs were allowed discovery. This is routine in the New York court as it was cited by the judge. On the 17th of March 2025, UMG responds to Drake's complaint with their motion to dismiss. They had added Protect Black Art Petition, which is a movement for lyrics to not be used in courtrooms like is being used in this particular case. They also included exhibits of all the songs in the battle, Drake's previous diss tracks like Back to Back and Doppy Freestyle for the record. UMG had argued that Drake failed in his claims of Not Like Us because it was hyperbole and opinion, therefore it was protected and non-actionable, citing Rappaport versus Barstool Sports, showing case law that the statements made in the context of hostile and hyperbolic feud is a strong indicator to the reasonable reader that the statement is not expressing or implying facts. Keyword expressing or implying any facts. Keep this case in mind as we go on. But before I move on to the next event that happened during this time frame, I just want to go back to that Protect Black Art exhibit, because back in 2022, Drake, Megan Thee Stallion, and other artists like John Legend, all of them have signed an open letter in regards to this Protect Black artist movement. The movement is a move to limit or completely prohibit the use of rap lyrics in court. As I said earlier, Drake has signed this particular open letter supporting this particular movement, and yet we are seeing him back in court today using rap lyrics to say that he has been defamed, which would be decriminalizing of lyrics because there are civil codes to protect citizens from being defamed. Anyway, let's continue on with the history part of the video. On the 16th of April 2025, Drake files an amended complaint and all three claims remained. He was using comments from Twitter to support his claim, saying that these people really did believe the lyrics in Not Like Us. He also claimed that UMG artificially used bots to inflate Kendrick's Not Like Us numbers. However, the wording of his allegations had changed completely, because on section D, paragraph 173, he alleges that UMG had turned a blind eye to bot usage and failed to exercise their power to stop all of this defamatory activity from going on. This was a far cry from the allegation in his initial complaint on paragraph 199 to 201, where he alleged direct involvement by UMG purchasing the bots to inflate the streams. For me, this was kind of a telltale sign that this was not really going to go anywhere, simply because his actual malice claim is now significantly weaker. This particular claim is very important, because even if you can prove that yes, Not Like Us was a statement of fact and it was defamatory, even if you can prove all of those things, based on the precedent set in 1964 with New York Times and Sullivan, you have to meet this bar where it says that UMG either knew it was false and posted it anyway, or they acted in reckless disregard. The best bet that he had by saying that they had direct involvement is that they knew that it was false. So, but now turning a blind eye, well, how does that meet the reckless disregard standard? That, in my opinion, this was the beginning of the end. On the 9th of July 2025, oral proceedings were held after UMG had filed their opposition to Drake's motion to dismiss. The judge was asking if there was enough facts about the broader context so that she can go off and apply the proper legal test and come to a decision about how a reasonable listener or what a reasonable listener could conclude in hearing these statements. And from this, Ransom responds saying that the amicus brief is going to explain rap battles and the diss tracks and the songs in the battle to consider, and there is no suggestion in case law that the court needs to limit themselves to a particular type of listener. So this means that this could either be the fans of the artist, that the court is not compelled to limit only for them, or that every listener has perfect knowledge of all the information. So this also means casual listeners who does not care about rap, know anything about diss tracks, know anything about hip hop. They are just coming in to hear it, and they can also be considered reasonable listeners. So basically, it's taken as a broad view rather than, oh, what would fans think or what would casual think. So UMG's lawyer, Mr. Ransom, goes on to explain the Torrain versus Lou case law to the judge, saying that she must follow it, and says that the court explained in that particular case that in determining whether a statement is actionable, they should look at the context. However, the judge did challenge Mr. Ransom on this particular point, saying that is all well and good, the context is there, but a reasonable listener listening to certified lover boy, certified pedophile, that particular line, that could mean that Drake is officially a pedo, and was asking, if Kendrick was making a reference to certified lover boy, how is a reasonable listener who does not know the context to even place certified lover boy to actually understand the hyperbole, how would they know that Kendrick is not saying that this is actual fact, you are a certified pedophile? And says this would require a listener to have a certain depth of understanding to piece the two together. And in response to this, Ransom went on to give a governing case law that answers that particular question, but I'm not going to go into that. I just brought this up to show that the judge was not just lying, bending over and just taking it, and she was actually not partial or showing partiality, I should say, because end of the day, this is actually a very good fact to present. It's an opinion if it's a reference and it's understood to be a reference. So then it's an opinion. If it's not understood to be a reference, then it could be a fact. And the could be part is the crux of this particular case. Anyway, let's move on from the oral proceedings and let's go on to the 14th of July 2025, where Kojo Asamoah was subpoenaed by Drake's legal team to appear for a deposition. This was a much talked about topic online due to Kojo being mentioned in Family Matters diss track. He was mentioned also on the 18th of August 2028 filing, where Drake cites that UMG was using covert tactics to promote defamatory material. I'm cautious to say that he was actually used because he made that claim to a lot of the executives and directors, even YouTube, these are all of these places were deemed to have been using covert tactics and publishing defamatory material. So don't come at me. I don't know what role Drake is saying that Kojo is playing here. But like I say in my videos, let me know in the description if I've made a mistake. I don't want to misinform anyone. I will correct it and put a pin comment and also update my website to reflect the corrections. Anyway, let's move on with this. On the 7th of August 2025, the judge orders a subpoena to serve Kojo Asamoah by Drake. On the 7th of August, the same day, judge denies the motion for consideration, citing that the amicus admission would not aid the court with this matter. This means that the judge is not relying on their motion, the amicus motion, in regards to the use of rap lyrics. However, she can still rely on the black art exhibit submitted by UMG in their motion to dismiss. This is very important because, as we learn in the oral proceedings, Mr. Ransom had used, or I should say, had cited the amicus brief and instructed the judge to go ahead and use that to understand the context. With her removing this amicus brief, this means she was not even thinking in a sense of a rap battle. She was just thinking in a sense of two people having a feud, at least in my opinion. But I'm digressing right now. I will discuss all of that later on when we go in to analyze the dismissal. On the 12th of August 2025, if you remember this, a lot of people were up in arms because Drake filed a compel motion for production of documents including Kendrick Lamar's contracts and UMG's history of censoring, including the censoring of the story of addict. This is going back to the Pusha T and Drake beef. He is now putting it out there for the public to know that UMG had censored the story of addict from coming out. There's been a lot of discussions about this, that Drake was the one to stop it. I have no idea. But it's very interesting that he's bringing this up in a lawsuit because he's trying to say that this is what they mean by UMG turning a blind eye, because they have previously stopped a release of a diss track against him that was potentially defamatory. So therefore, they should have acted here. At least that's the sense that I'm getting why he would bring this up and would be requesting documents to support his case by requesting this. And like I said, there was a lot of chatter around this day because not only did he file for the story of Idon, he also filed for documents requesting Kendrick's domestic violence history from 2014 to present day, communications and all documents relating to Dave Free and his relationship with Kendrick Lamar and his kids, and also whitelisting songs like Push-Ups, etc. Now that you know all of this background, yes, Drake fans, I'm talking to you. Now that you know all of this, now that you know that Drake has signed that open letter to not criminalize rap lyrics, not to use them in court, the compelling of the documents for the kids. Now that you know that he did not subpoena Kojo for the specific part of but activity played, that it was actually similar, if not the same, as the other people that he was submitting, including Deezer and YouTube, all of those people. Apparently they were all in on it too. Now that you know all of this, and if you still believe at this point that Drake stood a chance and was fighting for all black artists and the future of artists out there, if you still believe,
you're probably a loser, or at least like the most boring person that any of your friends know, and also possibly shitty and into underage girls and just like weirdo shit, just keeping it real. If that's your favorite rapper, not like you like some Drake songs, not like he goes off in the club, but if you like connect with Drake, if he inspires you, you probably suck. Yeah, we're done with the history part of the video.
So these are the reasons why the judge had dismissed this particular case. And we have to begin with what the judge had to consider. She has to consider and evaluate the fact versus opinion threshold that is very key in defamation law.
Well, the judge basically said this is the First Amendment. This is free speech. No reasonable person would take Not Like Us, Certified Lover Boy, Certified PDF as being a factual statement. And I find that interesting because I don't really know what a reasonable listener is. Like to me, a reasonable listener in this situation would be someone who understands hip hop. Reasonable hip hop listeners walked away from the battle also believing that Drake was a pedo.
But let's go into what she has to consider. In distinguishing facts and opinion, 3 factors guide the court's consideration: whether the specific language in issue has a precise meaning which is readily understood, whether the statements are capable of being proven true or false, because it is important to show the substantial truth of all of this after you have met the motion to dismiss, and after you have cleared that, you now have to prove that those statements were actually false. So this is the first step. The second step is coming. The second step would come if this motion to dismiss had failed. It would have been for Drake to prove, okay, are these truth or false? The third point of consideration is whether either the full context of the communication in which the statement appears or the broader social context and the surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. She goes on to say that the court will focus its analysis on the third factor. This inquiry is a holistic one which looks to all the overall context in which the assertions were made. Context includes the forum in which communication was published, the surrounding circumstances, the tone and language of the communication, and its apparent purpose. I want to focus only on the forum because I feel like this is where the case was basically destroyed, in my opinion. So the forum is where this particular feud had occurred, and she says that it occurred in a music recording. And the cases in which the judge relied on for this particular forum argument is the case of Style Iber versus Alphon. In this particular case, she highlights that the allegedly defamatory statements were published in a tape recorded telephone message that was played automatically to anyone dialing the private phone number that was given to labor union members. So think of it as those voicemail messages that you hear and automated messages that you hear when you're calling for customer services. You're not going to hear insults being hurled. You're not going to hear all of those things. You're not going to hear Donald Trump being called a pedo or being called on Epstein's list or something like that. If that was to happen in this particular case, if that was to happen in that kind of arena, then yes, it could be argued that this is asserting facts, because a reasonable listener would not be expecting to hear those messages. She goes on to say that the union had assessed a fine against the plaintiff after she had defied the strike order, and the firm message appeared after she had failed to pay the fine. The New York Court of Appeals, so this is a higher court than the court that we're currently in now, it basically found that the most significant circumstance was that the message was prepared and played as part of a union's effort to punish a former member. The court highlighted that in the emotional aftermath of a strike, when animosity would be expected to persist, particularly against a former member who was seen as a traitor to the cause, that a listener would not expect that any insult lobbed would be factual in nature. So, based on what this case law is saying, like I gave the example with calling customer service, but because this was in a setting where it was after a labor dispute and there was a lot of animosity going on, a reasonable listener is not going to take whatever is going on there as fact, because end of the day, let's expand on the example. One of the members' friends could look at it and be like, he's not a traitor. I don't agree with that. I don't agree with you saying that he is a traitor to the cause. Terrain versus Lou was cited by the judge, and she says that this court of appeal case held that the mentioned racist, pedophile, and other epithets were expressed opinion. She highlights that in this particular case, the plaintiff, Terrain, even said that he was going to sexually abuse his daughter, and it was ruled that no reasonable listener would take this to be a factual assertion. So there are two things to this. Because of the context of Lorraine calling Lou or saying to Lou that he was going to sexually abuse his daughter, Lou's response saying that he was a racist pedophile, there is no reasonable mind out there that would think, hold on, this has to be factual, because he is definitely a racist pedophile if he said that he was going to sexually abuse his daughter. No one is going to think like that. The reason why I say that is because someone would think and say, wait, pause. Wait, before I can think that you're a pedophile, are you actually going to rape his daughter? Because that's when I would think, yeah, you are definitely a pedophile. With that in mind, a reasonable listener is going to think he's only calling you a pedophile because you said you were going to sexually abuse his daughter. He's kind of in his right to even call you that. That actually makes sense why he would call you that, because you literally said this. So therefore, that is a protected opinion. The judge also relied on Rappaport versus Barstool Sports, and this is where she took judicial notice to bring in outside reports such as the Millie Bobby Brown statements that was made about having discussions about Drake.
I love him. I met him in Australia, and he's honestly so fantastic and a great friend and a great role model. You know, we just texted each other the other day, and he was like, I miss you so much. I was like, I miss you more. He's coming to Atlanta, so I'm definitely going to go and see him. I'm so excited, yeah.
You and Drake? That's awesome. That's awesome.
What advice does he give you? Like, what does he say?
About boys. He helps me.
What?
Yeah. He's great. He's wonderful. I love him.
What's his advice with boys?
You know, that stays in the text messages.
Plaintiff first posits that the line, say Drake, I hear you like him young, indicates that Lamar had heard from outside sources evidence confirming that Drake is a pedophile. That ignores that this line is reasonably understood to be a direct response to Drake's challenge to Lamar in 10-minute freestyle to talk about him, Drake, liking young girls. Heard it on the Bottom podcast. It must be true. This lyric clearly prods Lamar to discuss pre-existing rumors about Drake's interest in minors. Lamar's responsive lyrics are thus akin to the accusation of pedophilia in Terrain that the Second Circuit concluded constituted pure opinion, based on the context that the defendant disc jockey was using the term pedophile in response to direct, pertinent comments made by the plaintiff during a war of words and was not relying upon disclosed facts. So therefore, daughter, pedophile, tell him that he likes young girls, that's a gift from me. Say Drake, I heard you like him young. That's all this is. That's literally why this case was dismissed, in my opinion. What Drake was trying to argue is the reasonable listener is not going to be a person that's going to know the context, that is going to go back and listen to the context. What the judge is arguing, though, is because of case law, we have to look at the context, because there is a likelihood or a potential that this listener is going to want to naturally know more about what is going on how did this start? They would ask questions, how did this originate? And someone could say it started from push-ups, someone could say it started from tailor-made freestyle, someone could give the order, and then they go and listen to that, and they're gonna be like, oh, I didn't know it was this deep. But they're not gonna arrive at they're all spitting facts, because end of the day, if they arrive at tailor-made freestyle, they could make the connection that, hey, he's just calling you a pedophile, like you said. Listen, I know that there's a high likelihood that no one is gonna watch this video. I get it. I'm not a big YouTuber or anything like that, but I hate narratives, and I had to make this video in order to dispel this narrative that the judge was paid off by UMG. I had to dispel this narrative. I want to pose this scenario because this is UMG we're talking about. They have deep pockets. They are well known in the industry, so they can afford to fight this. Let's say that Kendrick made a strategic, an altruistic decision, right? He didn't decide to put it through PG Lang, but he was like, you know what? Let me help a black-owned label. I'm gonna pick one I just came across. They go by the name of Zobi Records. They have their own publishing, I believe, and they can publish other artists. Let's say that they do have publishing rights. I don't know for sure, but let's say that they have the same rights as Universal, and Kendrick had the altruistic heart to help that label come up, and he saw that this beef, it was going to bring a lot of eyes to that label, so he decides to release every single track on that label so that they can get the proceeds from this beef, so that they can get the publicity that they want. Let's say that was the case. Now Drake sues them. This label would not have the financial muscle to pull through this lawsuit to create the filings, because as we went through all of this, there was a lot of filings. Some of them was not even necessary, and with every filing that is made, that costs a lot of money. Litigation is not cheap, and the reason why I brought this up is because when you go into court, when you fight these battles, it is an expensive endeavor. And if Drake had won this, let's just say that he did win this, you would see labels, forget the big labels, they can handle the hits. But what about the little labels that are just trying to put music through, and they now have to face the prospect of worrying about a potential defamation lawsuit? So therefore, let's not even risk it. Like, let's micromanage everyone's lyrics. Let's do this. Look, listen, of course, like I said before, I used to be a DJ, so this part does affect me, and it's largely irrelevant to the video. But what I'm trying to say is, what Drake was doing is why the system is designed like this, is to put away all of this, because this was a frivolous suit. In fact, in its harassment claim, that you cannot claim harassment in civil court. He had to bring in a criminal code to try and say that he should be rewarded civilly for this, just so that his butt argument could work. Yes, it can be done, and there are provisions made in the system for judges to consider the possibility, but this is how frivolous it was. The defamation case on its own was never going to survive, and the civil harassment case never even existed. So what course of action did he have outside of business law, which is something which, if he was really interested in taking this to the man and really interested in recovering all this, he would have launched a civil RICO case, and he would have brought in the relevant people to build the case and say that these guys are running a criminal organization. Here's the proof. I am not a lawyer, I must make that clear. I just have an interest in the law. If you've made this far, you've got great taste. Make sure that you smash it, pour your sauce all over that like button if you find this video to be of value. Also, consider supporting the channel by becoming a tastemaker and join our great community by hitting that join button on YouTube and see the perks of becoming a member. You can also support us on Patreon, or by making a one-off donation, whatever your heart's content. The links are in the description for how you can support the channel. I appreciate every single one of you that have been supporting the channel. It's truly heartfelt. So if you got a taste for law, crime, cases, trials, you're already one of us. Make it official and become a tastemaker today. Also, we have other cases that we have covered on the channel, especially the deadbeat hurled case. It's a defamation case that I went through, going through the events and many of the facts that the media would not highlight. It might interest you. Go check it out. I go by the name of Heinz, your friendly neighbor ketchup man, and this has been The Ketchup.